Yes, good morning and welcome to the program Know Your Right on Lagoon Radio. It's Friday, the 17th day of June 2022. I am Anosike Chimese, your regular host on the program. Remember, you can download the app on Google Play Store and Apple Store. You can also follow us on our social media platforms. On Facebook, Lagoon Radio Nigeria. Twitter and Instagram, Lagoonradio.Ng. You can also listen to us directly via the link www.lagoonradio.ng. Remember, Know Your Right is our legal program where we educate you on your fundamental rights as a citizen of Nigeria. And this morning, we'll be looking at a very interesting topic. It's about a topic that concerns many Nigerians. Employer and employee relationship under the Nigerian law. Yes, employer and employee relationship under the Nigerian law. And of course, I'm not alone this morning in the studio. I have with me a legal practitioner in the house, Igodalo Esene. Igodalo, good morning and welcome to the program.
Thank you. Good morning. Thanks for having me.
Okay, now talking about the employer and employee relationship under the Nigerian law. Who is an employer and who is an employee?
Okay. An employer and employee relationship, like you've stated, that's what we're looking at this morning. An employer, simply put, so everybody can understand, is an individual or an organization. An individual or an organization that hires another person, to carry out certain obligations, to carry out certain duties in exchange for certain benefits. For example, benefits could be wages or salary. So an employer is an individual or an organization who hires another person or several persons to carry out certain obligations or carry out certain duties in exchange for a salary or for wages. Thank you.
Okay. Having said that, so literally, employee is the one who is hired.
Yes, okay. and an employee is the one who is hired to carry out those duties, those obligations, and then gets paid or is entitled to wages or salary based on the agreement between both parties.
Okay. Now, give us an understanding of what this relationship is all about before we talk about it under the Nigerian law. What's this relationship?
Okay, so the relationship, the employer and employee relationship, like flowing from the definition, is one that has to do with work, or has to do with work, engaging one person engaging the other to carry out certain duties. Now, in Nigeria, there are two classifications. When you talk about employer and employee relationship, two classifications in terms of, first, there is the employer and employee relationship that is referred to as statutory. It is governed by statute. That means it is governed by a written law. Now, a practical example of that is take university lecturers, for example. Now, the lecturers are the lecturers are the employee, the universities are the employers. Now their relationship is one that has, in law we say it has statutory flavor because it is governed by statute. Now the second ambit, which essentially is what we'll talk also about, is one that is governed except certain restrictions. It is governed essentially by contracts. We call it contractual relationship. So what it simply means from the definition contract or contractual relationship is it is governed the employer. The second one, the employer and employee relationship, is governed by contract. It means that essentially the relationship is governed by the agreements of the parties, what they agree on. That, okay, based on this our agreement, this is how our employer and employee relationship will go.
Okay, when we talk about that statutory and contractual, you mentioned agreement. Is there anything different? Are there no agreements on both, or is the agreement only on one side?
No, there's agreements. There's agreement on both. It's not only on one side. Some of the difference is, like I said, for example, the one that has statutory flavor, in terms of rights, obligations, and liabilities, you must strictly follow what the statute. The statute is a written law. So you must strictly follow what is stated in that law. For example, in terms of the wages, in terms of termination, in terms of benefits, it's outlined. You have to follow it as it is. The other one, which is contractual, you only reach these benefits, rights, and obligation based on what is agreed upon. Let me paint a quick scenario. For example, company XYZ puts out a vacancy post. Job seekers apply, and an interview is conducted, and then at the end of the day, the spot is for one person, and at the end of the day, they pick the one lucky person. Now, when they pick the one lucky person, they are expected to send an offer letter to the person. Okay, congratulations, this is our offer letter to you. Now, this offer letter is the agreement between the employer and the successful candidate, the employee. It will state the rights, obligation, and also the duties. For example, it will state the expected wages or salary. Now, it is left for that the employee now that has been given that offer, will go through, can also, decide to negotiate. You understand? Sometimes wages or salary can be negotiated during interview. Sometimes it might not be even after you have been given the offer. It is not the most that you must accept. You can, when you see the offer, for example, when it comes to salary, when you see it, usually there will be the gross annual gross salary, there will be the net, everything will be calculated, deductions will also be stated. You can look at it and say, okay, based on what I'm bringing to this organization, I think I deserve more. You can now negotiate, and whatever you agree, once you accept it, it becomes binding.
Okay, now let's bring in the law into perspective now. Having said this, a lot of agreements cannot go through without the law. Is there anywhere this relationship is stated in our constitution?
Okay, well, in the constitution per se, it is not stated in the constitution per se. What is stated in the constitution is the court to go to, which is the National Industrial Court. The National Industrial Court is the court that has exclusive jurisdiction to entertain all matters pertaining to labor and employment issues in Nigeria. So that is stated in the Constitution. However, there are laws that govern this relationship, and some of those laws are principally the major law, the number one law is the Labor Act. We have the Labor Act. Then we have other laws also that relates or govern this relationship, like the Employees Compensation Act. We have the Factories Act. We have the Pension Act. We have the Personal Income Act and the likes. All these other laws also govern the relationship, but principally the major law is the Labor Act.
Okay, let's talk a bit about the Labor Act. What does it entail? What is the Labor Act actually?
Okay, the Labor Act deals with, like I said, deals with the employer and employee relationship. It spells out what should govern the relationship between an employer and employee. However, the Labor Act does not apply to every set of employee, because in the Labor Act it says the act is applicable to workers, and it defines workers in two categories. Now, the first category are workers who are engaged in clerical duties. Workers who are engaged in clerical duties and the like. Then the second category are workers who are engaged in administrative and technical duties. So those are the categories that the Labor Act captures. Now, for those categories of workers that the Labor Act does not capture, it will now fall back to, it will now be governed by the contractual relationship between the parties, the employee and the employer. The agreement, whatever they agree upon, that is what will bind them.
Okay, now you mentioned something about the industrial, National Industrial Court. Yes. In Nigeria, where we are not privy, or a lot of Nigerians doesn't know their rights. What if there was no real agreement? Because of what is happening today, there was no real agreement. And when the table turns, can someone still approach the industrial court?
Thank you very much for this fantastic question. As a matter of fact, there are lots of employer and employee relationships that are not governed by a written agreement. Do we now say there is nothing that can be done? That's not true. Now, an agreement can eventually turn into a contract. Now, for contract, it is not a must that a contract must be in writing for it to be binding. By the law of contracts, there are different types of contracts. For example, you have a written contract. You also have unwritten contracts. As a matter of fact, you have oral contracts. There are contracts also that can be entered into by conduct. So to answer this question, even where there is no written agreement, although we as lawyers, we always advise that there should be written agreement, there should be a contract. Now, even where there is no written contract, it will not stop an employee who feels aggrieved from approaching the National Industrial Courts. You have, even if there is no written contract, as long as you can establish that employer and employee relationship, you can always approach the National Industrial Court, because establishing that relationship is not only going to be by the written contract. Of course, the written contract is good because it will spell out everything in white and black. But in the absence of a written contract, you can still approach the National Industrial Court as long as you can establish employer and employee relationship. For example, one of the ways you can do that, even if there's no written contract, if you can show pay slip or evidence of payment of salary that you have been receiving from your employer, that will suffice.
Okay, you're still listening to Know Your Rights, our legal program on Lagoon Radio. We'll go on this short break. When we come back, we'll talk about more. And remember, you're listening to Employer and Employee Relationship under the Nigerian law. And Barrister Igodalo is here. He will still be talking to us. We'll go on this short break. Yes, you're welcome back. You still know your rights. Our legal program on Lagoon Radio, your number one online gospel radio in Nigeria and the official radio of the Anglican Diocese of Lagos. We are transmitting live from the Archbishop's Palace right here in Marina, Lagos. And download the app on Google Play Store and Apple Store. Follow us on our social media platforms. On Facebook, Lagoon Radio Nigeria. Of course, we are live on Facebook. And on Twitter and Instagram, it's Lagoonradio.Ng. And you can make your contributions via our phone line 08189 524666. 08189 That's the number to call on the program. Yes. Like like I told you before, we've been speaking with Barrister Igodalo Esene. Barrister, now, having said this, now, in Nigeria, is it advisable before you take up any contract, you approach a lawyer?
Yes, yeah, yes. It is. It is very advisable before you take up any contract to approach a lawyer, because if you just approach a lawyer to review the contract, the letter of employment or offer letter, to review the letter for you, especially if it is something that you yourself feel there are certain terms or certain obligation or certain clauses in the offer letter that you might not be able to understand, or you're finding difficult to understand. You can always send it across to a lawyer to review and then advise appropriately. Because once that is not done, if you proceed to accept, it becomes binding on you, as long as because in law, once you voluntarily enter into a contract, it becomes binding on you. You cannot turn around to now say, oh no, I didn't understand what was happening. As long as it was voluntary, that means there's no any of the vitiating elements. You were saying, as at the time you signed, you were an adult when you enter into the contract and all of that. You were not under any sort of duress when you enter into a contract. So once you proceed and you sign, it becomes binding and you are bound by the terms of that contract. So it is always advisable, once you begin to have doubt, or there are clauses or terms in the offer letter or agreement that you're not comfortable with or you're not understanding, it is advisable for you to send it across to a lawyer to review and advise appropriately.
Okay, on the other side now, looking at a Nigeria where a lot of youths are desperate, in fact, a lot of people are hungry and looking for a job. How do you advise such people? Because a lot of them are looking for. I met someone, he was saying, even if it's something to put food on the table. So, what do you advise to such people?
Okay, well, I think still for such people, it is still my advice. Of course, we are in Nigeria and we know the reality on ground, but notwithstanding that, there are lawyers who do. You can still reach out to lawyers. There are lawyers who do a lot of pro bono work, for indigent persons, that is persons who cannot be able ordinarily to afford their fees. They do indigent work. Then also there are lawyers and also other organizations like Lagoon FM, for example. What you're doing now, which is very commendable, when you listen, you know certain things you are supposed to do. So there are organizations also helping out in enlightening and educating people about their legal rights, so that you won't fall prey or you won't make a mistake that you turn around to say, oh, I know. So there are things like that some those kind of people can take advantage of.
Okay. Again, let me take you back. When you talked about statutory and contractual. Now, this morning, on my way to work, I was speaking with a friend who is a contract staff in a bank. And he saw the flyer. He was telling me that he will not advise anyone to take a contract job at the bank. Now, I asked him, he said he don't know if he'll be listening, but I should help him and ask if can a contract staff sue the bank which he is working under, or is he going to sue the what is it called, the outsourcing firm that he got the work through, because that he felt that a lot of his rights benefits have been deprived from him in that firm.
Okay, this is a very interesting aspect, because even in Nigeria, this aspect is an aspect that I within the legal community is still developing. The courts are beginning to look. The NIC is beginning to look into it and also make pronouncements in this regard. Now, before the thinking used to be that, a contract staff, whenever there's any issue, a contract staff can only take it up with the employer, that is the outsourcing firm. Now, just like you mentioned, contracts. Now, from in the beginning, I mentioned the fact that what we are talking about is employer and employee relationship. Now, before you approach the court, or when you want to approach the court, one thing you must establish, which is fundamental, you must establish that relationship. I have an employer and employee relationship with you. That must be established. Now, in this scenario, the contract staff who is employer. Who is his employer? The outsourcing firm is his employer. Okay. So the employer-employee relationship is between him and the outsourcing firm, not with the bank. Not with the bank. So the thinking before, or the position used to be that if there's any issue, you will take it up with your employer, which is the outsourcing firm. So you won't have any remedy or relief against the bank, for example. But now, that has begun to change, in the sense that if the contract staff can establish, please, very fundamental, if the contract staff can establish that the bank or whatever organization is seconded to also has some level of control over his duties, then he or she might be able to also sue if there's any issue with that company or that bank that he or she is seconded to.
Okay,
but it's still a bit dicey.
Okay.
Yes, but
okay.
that's the shift. That is the shift right now. Yes.
Okay, you're still on to Know Your Right, our legal program. We'll go on another break. When we come back, it will be the concluding moments. But we will look at the termination of contract, and also when you hear mutual agreement, what does it mean in this employer and employee relationship? Keep listening to us. We'll be right back. Yes, you're welcome back. It's still Know Your Right, our legal program on Lagoon Radio, your number one online gospel radio in Nigeria. Listen to us via the link www.LagoonRadio.Ng. You can follow us live on Facebook as Lagoon Radio Nigeria /Facebook. And you can also visit our website, www.lagoon.news. And on YouTube, yes, if you missed the program, you can go back to YouTube and watch. It's Lagoonradio.TV. And yes, Barrister, another question. Somebody said, please, can the federal government do away with this contract staff and let companies be responsible to their staff?
Okay, so the thing is, we the thing is, for now, I think maybe that might work when the Labor Act, if the Labor Act is eventually, amended, that might work. But for now, the court has pronounced that, some people were agitating initially that it is unlawful, but the court has pronounced that it is lawful. I think it is probably should be regulated better. It should be regulated better. If it is regulated better, probably, some of the complaints, will be addressed. Because the truth of the matter is, if you look at the unemployment statistics, if you decide to do away with that, can the companies absorb these numbers of people who are contract staff? Can all the employers that we have currently absorb everybody? It might lead, if you do away with it, it might lead to further unemployment, because some employers will not agree to take them on fully. So it's a dicey situation. But I feel if it is better regulated, pending when our government addresses the issue of unemployment, because unemployment is what is actually leading to such kind of arrangement. So I think it should be better regulated, pending when our unemployment can be better addressed.
Okay, now in some relationships we hear mutual agreements, especially maybe in football, when he say his contract has been terminated based on mutual consent. What does that mean?
Okay, so we still go back to what I mentioned earlier, that it is important, very important, to have your employer and employee relationship documented. Have a written agreement, have a written contract. Now, it is a relationship that started on a premise. So since it started, there is always a clause or certain terms to terminate it. So you are talking about termination. Now, in the contract of employment, at least I know most or all, there will always be the issue of termination. Termination, that is, just as the parties agree to come and begin the relationship, there is the option to also decide that, okay, this relationship, for whatever reason, we are no longer interested. Now, your question, mutually agree. Now, if you check in the offer letter or agreement, there is usually terms for clauses that deals with termination. There is unilateral termination based on certain conditions. There is mutual termination. Now, mutual termination simply means that it is the termination now. That is the relationship, the employer and employee relationship has come to an end based on the agreement of both parties.
Okay.
Both parties, for whatever reason, they have both agreed that, look, this relationship we don't want to continue. So it is both parties. It is at the decision of both parties that is bringing the relationship to an end.
Okay. Okay. We have another question. Someone asked. He said, "Thank you, Barrister, for educating us, but there is something you people have not touched. I want to know the difference between a public sector and a private sector. What are the disparities?"
Okay, so a public sector, when you are talking about public sector, essentially you are talking about governments.
Okay.
In Nigeria, within the Nigerian context, public sector, you are essentially talking about within the labor and employment and Nigerian context. You are actually talking about public sector, you are looking at government worker, local government, state, federal. Those are referred to as workers in the public sector. So now private sector has to do with private businesses, organizations, companies, and the likes. So that's the difference.
Okay, now let's look at the position of the law. Having said all this now, if someone, like we mentioned earlier, in a country like Nigeria where a lot of young people are desperate and a lot of them don't know their rights, what if, especially in the contractual agreement area, what if someone feels that he's aggrieved? So when someone is aggrieved, what is the right step to take?
Okay, so once someone is aggrieved, even as a lawyer, the first thing I advise is not for you to rush to court. When you are aggrieved, some contracts stipulates how to seek redress, some don't. Now, but now if it is, there's usually, I always advise to explore the internal mechanisms to seek redress. That simply means that if you are not looking to walk away and you don't want to terminate, you just feel aggrieved over certain issues within your organization or company, then you should first explore the internal dispute resolution mechanism. For example, if you have a supervisor, if you have a line superior, reach out and don't make it oral. Ensure that it is formal, in the sense that if it is an organization where you can send a mail to your supervisor and expressing your grievances, ensure that is done. If it is one that is not too structured, where there's no mail, send a message, send a text message, but just ensure that it is formal. Express your grievances and appeal for a redress. Then if your supervisor, if nothing is coming, send a reminder. If your supervisor is unable to address, the next person, just try and exhaust, the internal mechanism for dispute resolution. If that doesn't work, then you now begin to think of outside alternative or outside option, which is consulting with a lawyer.
Okay, now in Nigeria, where we can say there is a slow pace of justice, you may approach the court. How quickly can someone get justice when it comes to all these industrial matters?
Well, one thing I can say, I can't tell you how quickly or how not quickly. I can't say. But one thing I can say for certain is that the National Industrial Court, if there is one court that should be given thumbs up in Nigeria, the National Industrial Court should be the number one court. It stands shoulder above its peers. It is doing fantastic job in terms of, you can go online, they have a website, you can follow them online, you can check their website. They are really, in terms of doing a fantastic job in relation to justice dispensation. They are doing a fantastic job. So I implore more people to try and seek redress who are aggrieved, to approach the court. The court is an open court, embraces, as long as you can establish your claims, you definitely most likely get justice.
Okay, let me take you back again before we conclude. Now, in Nigeria also, it is said that we are fast becoming the poverty capital. Now, what if someone is aggrieved and also he doesn't have the money to seek the services of a lawyer? What is the right step again?
Okay, so going back, if somebody is aggrieved and wants to approach the National Industrial Court, the National Industrial Court, like most other courts too, but for the National Industrial Court, there is an avenue to approach the court as an indigent person. Yes, there's a provision there. I've even advised people, there's a provision that allows you to approach the court as an indigent person. Now, when you approach the court as an indigent person, it waives so many financial obligations, and the court can, even on its own, looking at the merits of your claim as an indigent person, appoint a lawyer for you that will handle the case pro bono, free of charge.
Okay, after the pro bono, is there something to pay back again?
No, there's nothing. As long as it is pro bono, there's nothing you're not going to incur any financial obligations.
Okay.
You're not going to incur any financial obligations.
Okay. Now, before we go, what will be your advice to a lot of Nigerians, especially the young people out there seeking for job?
Okay, so my advice would be they should keep doing your best in terms of keep building your capacity, keep building your capability, and then keep putting yourself out there to get opportunities. Now, when there's an opportunity, a job offer, if you don't understand the terms, reach out. There are lawyers, who can help out, give free legal consultation, render pro bono services. Reach out to a lawyer to help review, the terms of the contract, or review the contract and give legal advice or advise appropriately. Now, and also, once where there's a dispute where you are aggrieved, for me personally, I always advise try first and foremost to explore the internal dispute resolution mechanism. Because you mentioned you were asking, okay, how fast can a matter go and all that. So if it is possible to resolve a matter out of court, amicably, fine and better for everybody. So explore, once there's a dispute, once you are aggrieved, try and explore the internal dispute mechanism before, because even when you come outside to consult a lawyer, as a lawyer, I'm also mandated to first and foremost explore settlements out of court. It is if that doesn't work. So even after you've explored your internal mechanism and you come to me, I'll still reach out to your employer and say, okay, how can we settle this out of court? If that doesn't work, before we now say, okay, let's meet in court. Thank you.
Okay, thank you, Barrister Ighodalo, for talking to us this morning.
Thank you very much.
We hope to see you when next week.
Thank you very much. It's been my pleasure.
Okay, and thank you too for listening to the show. The legal program returns again next week by same time. And also thank you to our producer Olumakaiye Ajedi for pressing the right buttons. Do enjoy your weekend. I am Anosike Chimezie. You have a lovely day.